This particular judgment or today's Supreme Court judgment comes out of a tribunal matter which pertains to uh, computation of compensation due to death in a road accident. Now, as you know, this claim usually go to tribunal, and in this particular case, a student died in a road accident due to negligent on the other side, and in the motor accident claim tribunal, the compensation that was awarded to this to the claimant was around 7 lakh. If we scroll down a bit, I think the amount is somewhere here. Yes, here. So based on the evidence and everything, the tribunal awarded 7 lakh as the compensation amount. Now, aggrieved by the decision, the matter went to High Court, and then subsequently it went to Supreme Court. Now, here, one thing that is to consider, that is the person who died. Now, since it was a student, and since student doesn't have an IT return file or any sort of salary structure, usually unemployed, considered as an unemployed. In that situation, what tribunals do, or this tribunal does, is it takes the minimum wage as a earning capacity, and from there it calculates the compensation amount. Now, this section I just have highlighted because it's quite funny. It is funny, but it is also a very serious, depending how you think about it. So when tribunal was assessing the amount of computation for lawyer fee, it assessed as 11,000 rupees. Now, all the advocates, we know it very well. There is probably no, or maybe none actually, advocates who would go to tribunal for 11,000. So whether they are, whether tribunal is ignorant about that fact, or they are willingly blind uh, towards this aspect, that probably would require further investigation or consideration. But anyway, for that only I have highlighted. Now, when the matter subsequently went to High Court, the compensation amount was increased up to 23 lakhs. Here you can see the total compensation as enhanced by the court, and the claimant was still aggrieved by it, and then matter ultimately went to Supreme Court. Now, the reason why the amount was uh, different in this case, because they used the minimum wage as 10,000 for a student. Sorry, I think somewhere around, or sorry, the minimum wage, that is the 5,000, something like that. So they took that amount into consideration. High Court did that, which is again a bit funny when it comes to considering today's socio-economic structure. I do not know uh, what was the rationality behind it, because when it comes to computation of alimony amount or the maintenance amount, whether it is a family court or the high court or the supreme court, uh, I mean, somehow their imagination runs everywhere. They are well considerate. uh, they are very liberal in terms of the reasonable expenses of the spouse, everything. even if maybe the spouse is illiterate, has zero capacity to earn, and maybe even prior to marriage, the spouse standard of living was maybe some coming from mediocre, but after the marriage, subsequently, it has to be as per the standard of the other spouse. So that sort of rationality or reasoning uh, is shocking uh, when it comes to calculation of computation that comes out of this motor vehicle or death. To, so, but anyway, that's a different argument, I believe, altogether. But I would, this is the case that I would like you to remember. This will help you if you're practicing in a tribunal or maybe you are advising. So, in case if there is a death of an unemployed and who is a student, now usually this Navjit Singh versus Harpreet Singh case in the year 2020. It was a similar case. In that case, also, there was a death of a student and who was considered as unemployed. But what Supreme Court did, uh, or the reasoning was that since he was a student and probably once the course is completed, he would get placed in some corporate, and whatever the possible salary that he might, or let's say a common average packages that are offered across various engineering colleges. So that amount, Supreme Court in this particular case, or in this uh, Harpreet Singh case, what Supreme Court did, they took that amount as a uh, minimum wage, or in this case, the income, and from there it calculated the rest. Now, here also, to some degree, I do believe uh, some amount of error is there, or if it is not error, I think the reasoning could have been improved to some degree, and I'm going to tell you how. If it is a student, and let's say the student is studying in a good school, and what can be taken into consideration is the uh, packages that are secured by the previous batches, maybe the median amount. So if of a engineering college, the medium salary that was offered to the students during placement is 30,000, 40,000. So that amount can be taken. So though this will vary from college to college, but still I think if Apex Court had applied that mind, this would have been much better rather than going for 20,000. Reason being, uh, most of the colleges, engineering colleges, depending on the city, so, for example, if it is in West Bengal, still minimum you do get 30,000 uh, per month package along with some additional benefits. But if the same job is offered in some other cities such as Hyderabad, maybe Pune or Bangalore, it increases drastically. So, I mean, most of the time it will be the double. So if it is 25 here, it will be 50 there. But anyway, so my just contention is that that reasoning would have been much more, uh, much more. What would you say? Parallel to the timeline and also the common, what would you say, phenomena in that regard. But anyway, so there is that, and here the Supreme Court at the end, the compensation amount increased up to 34 lakhs and something along with the interest. One striking feature, if you are practicing, and even if you do not practice, you would know, and I have seen in many, many judgments, judgments that pertain to this tribunal calculation of compensation, it increases. So the tribunal does at a very nominal and sometimes very irrational amount they propose for compensation or as compensation. When the matter goes to high court, it increases to some degree, and when it goes to Supreme Court, it increases further. Now, a question that arises out of it: why this sort of behavior? A tribunal is supposed to follow the footsteps or the reasoning or the judgments of apex court. But this particular phenomena is something that I witness or can be witnessed almost every time. Either they are using a different, or their contention, or rather the intention or the motivation, they are different. uh, I do not want to bring any allegation, but it's the behavior or this pattern is something that can be doubted to a great uh, extent, why this thing is repeating every time, because they're supposed to know these judgments, they're supposed to consider uh, at the on the same footing the way apex code does. But the reality is very different. And this, and how the sad part is this: not everyone is capable enough to go till the highest court of justice. Simply 70-80% they will not be able to pursue it. So basically what they are getting from the tribunal is not at all justice, it is the opposite of justice. Thank you.